Okay, so time for our next video that I told that I'll upload soon. In the previous video, we were doing chapter 2 and covered from section 10 to section 14. And because my device got heated up to a great extent, I had to stop the video. So we'll just do a quick uh, recap and then start off with section 15 to 30, and we have to do it fast as I intend to keep the video short. And let's dive in. So what did we read before? We read that in section 10 what agreements are contracts, which we kind of somewhat derived from the definition part only. And then we read what is a who are competent to contract, that is when other parties allowed to contract, which parties are allowed to make a contract, legal contract. And then we read what is sound mind for the purpose of contracting, which was one of the competency clause in section 11. And then we read about what is free consent, what is consent, and then what is free consent. And under section 14, which actually embodies what essentials has to be there to not constitute into a free consent, otherwise consent will be free. So we will now do the sections which will cover the elements that will not make the consent free. That is starting with coercion, which is threatening or to do some unlawful activity to get the consent of a person, which is again something that doesn't amount to free consent. Explanation: it is immaterial whether IPC, and which is also punishable by IPC, it is immaterial whether IPC is or is not in force in place where the coercion is employed. So, and then we'll move on to section 16, that is undue influence. So what is undue influence? It is a relation that is subsisting between the parties that causes us to derive whether undue influence can be there or not. Say if there is a fiduciary relationship between the two parties, or say if one party is in an authoritative position compared to the other party, then that party can uh, influence passively, not I'm not saying actively, so passively to get the consent. So that is undue influence defined. And next we have fraud defined, that we all know what fraud is. So if that is done, then following acts. So some acts are given, that is 1 to 5 subclause, which these acts, if these are done, then it will constitute a fraud. And if these things are done, then we cannot validate a contract, which is the suggestion as to a fact or which is not true by one does not believe it to be true. That is, we suggested someone something which is not true, and I know that is not true, but still I suggested it. Or the active concealment of a fact, that I know that the horse that I'm selling, or the say a cart I'm selling, the cart has a broken wheel, or the horse that I'm selling is blind, so I'm not saying it. So that is active concealment. Promise made without intention to perform it, I'm say giving 10 months of I'm taking 10 months of grain from the next person, and I have no intention to pay for it. So that is a promise. I'm saying that I'll pay for it, but I have no intention to pay for it, and I know it in my mind while doing it. So the consent that the other person is giving, that yes, I'll give you the grain, that consent is not free, will not be considered free when he will sue me in the court of law for specific performance. The court can say your consent was not free because they have to give evidence that I had in mind at that time that I have not intended to pay the money and take the grains. So that they have to prove, burden of proving is on them. So once they can prove it, the court will hold that his consent, the other next person's consent was not free, and the consent, and if it can become voidable at his option. So whether he wants to rescind it or he wants to go on with the contract. If he wants to go on, then I'll be made to do specific formats, and if he wants to rescind it, then I have to give back the grain or the money that I have taken, price of the grain, which I might have already eaten up, and any other act fitted to deceive, something that is made to deceive, any such act or omission as the law specifically declares to be fraudulent. Whatever is said to be fraudulent under the any of the penal laws or any other laws. Mere silence uh, as to facts likely to affect the willingness of a person to enter into a contract, that is not fraud. Unless the circumstances of the case is that he has a duty to speak, but he chose to keep silence, then it will be equivalent to speech. Then it will be equivalent to speech means then it will be then the consent will can be held that the other person's consent is not free or fraud has been committed. But otherwise, if he just stays silent about a fact that he need not tell, the examples are given. He sells by auction to be a horse which he knows to be unsound. He says nothing to be about the horse's unsoundness. This is not fraud. Again, um, B is A's daughter and has come of age. She has become 18. Here, the relation between the parties would make it A's duty to tell B if the horse is unsound, taking the same example. So, uh, this is how we compare it. Next, we move on to section 18, misrepresentation. So, this is also another factor that makes a contract voidable. Misrepresentation means and includes. Here are also some acts given, that is 3 acts they have given. If these things are done, then it will amount to misrepresentation. The act will amount to misrepresentation, and the consent will be held by court to be not free of the next person, the person affected, and at his option the contract will become voidable. So it means the positive assertion in a manner not warranted by information of the person making it, of that which is not true, though he believes it to be true. So he is positively saying that, yeah, this happened, but he knows this did not happen, but he knows that this happened. So that is a misrepresentation. So that has to be proved first, that while saying it, he has in mind the truth of it, the real truth. So he knows it, but he's saying, no, I don't know. That didn't happen. No, he's not only saying that I don't know, that is another thing. He's saying that, yeah, I don't know about it, but he's saying the opposite thing. So that is something. So again, any breach of duty which without an intent to deceive gains an advantage of the person committing it. So any advantage, if it means to commit any, means to take any advantage, that is also amounts to it. Causing, however, innocently a party to an agreement to make a mistake as to substance of the thing, which is the subject of the agreement. That is to say I'm buying, say said that A has promised me to sell the white horse, but I'm buying, say, a grey horse. So there is a mistake, and that is actually caused by the seller. So that is also will amount to misrepresentation. That is the subject of the agreement. That's that. And then there are some cases, and then we move on to section 19, that is voidability of agreements without free consent. So here in this section, it is said that whatever we said, that if these things exist, that is coercion, undue influence, fraud, misrepresentation, then that we read from section 15 to 18, then the consent will be called not to be free, and it will become voidable at the option of the other party, the affected party. A party to a contract whose content consent was caused by fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed, and that he shall be put in a position in which he would have been if the representation has been made true. So that is what is the clause of voidability, that you can either rescind it or you can either um, intend to keep it. So in case of fraud and misrepresentation, the person can keep it, and in other cases also. Exception is there. So what is the exception? If such consent was caused by misrepresentation or by silence, fraudulent with the meaning of section 17. That we, what did we read? The example of misrepresentation by silence. That is, A sold a horse to B and he knows the horse to be unsound, but he didn't tell B. Now B is A's relative, say a very close relative, and he has come of age. So then it will be misrepresentation by silence. So that is what we read. So if the contract has been caused in that manner, the contract nevertheless is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. So if, say, B had already taken a tour of the horses the day before, and there he was shown each of the horses, talked about it in detail and everything. So then it would be easy for him or any prudent man to collect the information about the unsoundness of the horse and keep it in his mind. So then if his relative doesn't tell that yeah, this horse that I'm selling you is unsound in a proper manner, then it won't be misrepresentation by silence, because he could have discovered it by ordinary diligence. So that is an exception. We have an explanation here: a fraud or misrepresentation which did not cause the consent to a contract of the party on whom such fraud was practiced, or to whom such misrepresentation I'm sorry, I'm getting a bit jumbled up. I actually am a bit sick today. Not sick in that manner. I am not feeling well, and I had to lie down a bit. But now I'm feeling better, but not completely better like the other days. So if my viewers have seen the previous videos, then they have seen that how elaborately I do it. However, I intended to keep it short, and that's why I skipped many parts. So please state in the comments if you want me to cover those parts in detail. Then I'll do it in other video, another video, or if not, then not. Okay. So illustrations we have. A intending to deceive B falsely represents that 500 mounds of indigo are made annually to A's factory, and thereby induces B to buy the factory. The contract is voidable at the option of B. So here are some examples that is given of all the from 15 to 18 combined, from which we'll know. And then we move on to 19A, power to set aside contract induced by undue influence. So now we move on to undue influence. Okay, so with what is undue influence we read before. So now we will see that what is our power if we have been made to do something by undue influence. How can we set it aside or keep it if you want to keep it? When consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of the party whose consent was so caused. There is the same thing written. In any such contract may be set aside either absolutely, or if the party who was entitled to avoid it has received any benefit thereunder upon such terms and conditions as the court may seem just. So it might be set aside, or it might be accepted. So that is what is written here. Okay, let's describe with the illustration. A's son has forged B's name to a promissory note. B, under threat of prosecuting A's son, obtains a bond from A for the amount of the forged note. If B sues on this bond, the court may not set the bond aside. So, because the whole thing is not quite done in a proper way. Another example, this is a bit jumbled up. Another example, A, a moneylender advances rupees 100 to B, an agriculturist, and by undue influence induces B to execute a bond of rupees 200 with interest at 6% per month. The court may set aside the bond, ordering B to pay rupees 100 with such interest as missing just. Okay, then we move on to section 20, agreement void, where parties are under mistake as to matter of fact. So this I am doing quickly. Section 20, 21, and 22. So basically what is written here is mistake. The other criterias, that is coercion, undue influence, fraud and misrepresentation, that makes the contract voidable, merely voidable. But in case of mistake, there is no voidability clause. There is only either mistake will make the contract valid or mistake will make the contract void. So when does it become void? It becomes void when both the parties are under a mistake of fact. Say A thinks that he's selling him this horse, the white horse, and B thinks that he's buying the grey horse. So both the parties here are under a mistake because the horse that actually is sold is neither white nor grey. So the contract is completely void. So an example will make it clearer. A, being entitled to an estate for life, A agrees to buy from B a certain horse. Yeah, we get the horse example. It turns out that the horse was dead at the time of bargaining, though neither party was aware of the fact. The agreement is void. So this is a better example than the color of the horse. The horse is dead only. Or say the horse doesn't exist. The horse is not even there. It has been sold before. So that would be a better example. So A also thinks the horse is still there. B also thinks, yeah, I'll buy it. But it has been sold before. Or it has been dead. So that is that. Then it becomes void. But effect of mistake as to law, which is embodied in section 21, what we find is if say if it is a mistake in Indian law, then it's completely valid. There is but if it is say a mistake of foreign law, then if both parties are say if both parties have made the mistake, then it becomes void. If one party has made the mistake, then it becomes valid. But in case of Indian law, there is no voidability because we should know the Indian law, it's our country's law. Then if there is a mistake of law by both parties or any one parties, then there is no clauses of no chances of voidability or void. It's completely valid. But if it is some law of foreign land, then if both parties make the mistake of that law, then it becomes void. If one party mistakes it, then it becomes valid again because the other one knows it. So there are examples. A and B makes a contract grounded on the erroneous belief that a particular debt is barred by Indian law of limitation. The contract is not voidable. Then we see that contract caused by mistake of one party as to matter of fact. So if one party makes a mistake as to the matter of fact, then what happens? A contract is not voidable, they are saying. If it's not voidable, then it's valid. If it's not void and voidable, then it's valid. If one party mistakes the fact, say A is selling the white horse and B thinks it's the grey horse, but A has registered it properly, written in the contract and everything. He has set out the clauses, but B is under somewhat in some mind that yeah, I'm buying a grey horse, so then it becomes valid, no voidability because you should have known. Next we move on to section 23, what consideration and objects are lawful and what are not. So basically, here we see that this is what we also derived in the other chapters. What considerations are not lawful? That is, if it is forbidden by law, is of such a nature that it will defeat the provisions of the law. This has to be uh, explained by examples. So these have to be actually um, explained by examples that are given here, illustrations. So when will the contract become not lawful? If it is, if the consideration is forbidden by law. Now, an unlawful consideration makes a void contract. It's not voidable. So, what contracts say are voidable by law? When the consideration is unlawful. So, what considerations are unlawful? Let's explain with an example. A promises to obtain for B an employment. Okay, not this. The object. Mostly the object is unlawful. See, A, B, C enter into an agreement for the division among them of gains acquired to be acquired by them by fraud. The agreement is void as its object is unlawful. So the object could be unlawful. The consideration can also be unlawful. That is, A agrees to, say, I'm giving an example. A agrees to sell B some grains, and B agrees to give money for it, the amount. Now B pays A, or say next person, A, remove AB. Say I am selling something to the next person, some grains, 10 months of grains, and the next person is giving me some money for it. Now he gives me money through forged notes, or the notes are not real, or there's some problem with it. So then it becomes void because the consideration is void, unlawful. Next is of such a nature that if permitted it would defeat the provisions of any law or is fraudulent. So we read that if fraud has been committed, those the acts, so then also it becomes void. Then it becomes voidable. I'm sorry, because fraud doesn't render the contract void. Fraud renders the contract voidable at the option of the affected party, who can either accept it or rescind it. Involves or implies injury to the person or property. If it say harmful to the property, say I'm not giving a proper value or something like that, or I intend to demolish a heritage building, so that is also not right. So then it will become completely unlawful, completely uh, uh, unlawful. So consideration will be unlawful in this case. So this will render the contract void. Unlawful considerations makes the contract void, and the court regards it as immoral or opposed to public policy. So this can be, say, take an example. uh, yeah, so give any example of immoral. Say a not say I'm like, say, next I have uh, made a promise to the next person that I'll buy some obscene books or CDs from other person which is banned by the government. So that then it becomes immoral and cannot be performed. So it becomes void. The whole contract becomes void. So that also becomes illegal. Okay, so next is we move on to what are void agreements. So these agreements that we are going to read, that is from 24 to 20, yeah, 24 to 30. These agreements are all void. So what are the void agreements? Agreements void if consideration and objects are unlawful in part. So these that I've read now, these are completely void. Not only this fraudulent renders the contract voidable, but if consideration is itself in a fraudulent nature, say if it is done say by forged notes, then it cannot become voidable at option of any party because this is also illegal. So these are all the examples. This renders the contract completely void. And here, so yeah, if consideration objects are partly unlawful, so say partly he paid me through check, which is uh, which is okay, and partly through cash, which he doesn't even know that the notes are, there's a problem with it. So then also it becomes completely void. And then we move on to section 25. Agreement without consideration is also void unless it is in writing and registered, or is promised to compensate for something done, or is a promise to pay a debt barred by limitation law. So, an agreement that has been made without consideration also becomes void. But if it is in writing and if it is registered and if it promises to compensate something for something done, or it is a promise to pay a debt barred by limitation law, then it becomes valid, absolutely valid. Um, for example, voluntary service, natural love and affection, those things. Okay, so agreement in restraint of marriage is void. So any person who is agreeing that a person, a major person, has a right to marry anyone, it's a fundamental right. So if any agreement is made that you cannot marry this person, this is completely void. Agreement in restraint of trade. So these are fundamental rights. So it was written in the constitution that if any from 14 to 32, if any uh, other law, any other enactment supersedes, tries to be contrary to those part 3, then it will be void. It was clearly written. So that is what is given here. Any contract that is contrary to the to part 3 becomes void. So agreement in restraint of trade is void because every person has a right to pursue their profession, lawful trade and business and everything. And next we move on to 27. Yeah. 28. In agreement in restraint of legal proceedings, every person has the right to get their legal remedy. This is also another part 3, part 3 contradiction. I mean, superseding part 3, if any contract is made like that. So every person has the right to get legal remedies to enforce their rights. That is stated in section article 32. So yeah, agreement in restraint of legal proceedings shall be absolutely void. And then agreement is void for uncertainty. If there is an uncertain element in the agreement, then it also becomes void. So let's explain with an example. A agrees to sell B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. This agreement is void for uncertainty. And agreements by way of wager is also void. We have read that wagering is not something always legal. So if the agreement includes wagering, something by wagering, agreements by wager are void, and no suit shall be brought for recovery of anything. So that becomes void. The exception is horse racing, because this was done by people from a very uh, long time, very early time, done by uh, many people. So this is not void. Otherwise, it is void. Then this is okay. Wagering contract. A chit fund does not come within the scope of wager. This has been written. Okay, so this we end chapter 2 of the Indian Contract Act, which mainly embodies what are valid contracts, what are voidable contracts, and what are void contracts, and what is consent, what is free consent, that is the basic element to decide the voidability or validity or uh, yeah, whether it is void or not, and also the consideration factor and competency of the parties, unsoundness of mind. So that is what we read in chapter 2, along with illustrations, some case laws that I skipped, that is written in the Bear Act very much clearly. And yeah, we are done for today. Please let me know what I should do the next day. I am intending to read some stories also. I'll read some stories, and I don't intend to read it, you know, before and then come in the video and read it again, because I want to capture my true expression while reading the story. If I'm um, frustrated, and the frustration will show. If I'm happy, not happy, if I'm surprised, then surprise will show. See that undulation of emotions, I will show it. I want to capture in the video, along with some reviews that I make to myself. I want to share in the video. So yeah, or any movie or anything. The food review also I can do, but I'm not going out in much in restaurants or anywhere to do the food reviews. Yeah, I'm just not I have not visited any new cafes or any uh, popular restaurants recently, quite a long time recently. So I cannot do that now. Probably sometime later. I keep the option open, but I'll be back soon, hopefully. Until then, ciao.